Thank you for joining this presentation by one of our own, Ashley Adams. Ashley's been on the CJA panel in Phoenix for about 15 years, and she specializes in white collar cases at both the state and federal levels. Ashley's been practicing for 31 years, and she was formerly an AUSA in the District of Arizona and has also been partner at the Phoenix Law Group and O'Connor Kavanaugh. Ashley is almost a native of Arizona, moving here in 1988, but hails originally from Oklahoma. Ashley's a great resource to the panel on white collar cases, and she has graciously volunteered to talk to us today about restitution and the Federal Debt Collection Act. Welcome, Ashley, and thank you for being with us.
Well, thank you so much for having me. I guess you guys saved like the most boring topic, restitution and federal debt collection, for last. But I will do my best to make this very dry topic a little interesting for you, hopefully entertain you a little bit. And most importantly, I hope that you learn something that you can take back and help your clients with when it comes to restitution. And, I was really glad when Denise asked me to talk about restitution, because I think it's kind of like the forgotten stepchild. We're so focused on negotiating the best plea agreement that we can, focused on trial or sentencing, to keep our clients out of prison. And so we sort of are not thinking about the fact that a large restitution judgment could really impact a defendant and his or her family, for the rest of their lives. I think it's also important that we talk about restitution because I've seen a lot of defendants either get no advice about what's coming or they get bad advice. And I know not by you guys are awesome, but let me give you an example. Here in Arizona, we have the Homestead Exemption Act, which allows or protects, in other words, $150,000 of equity in your home. Well, that exemption does not apply under federal law, and there's a lot of bad advice given about that. Retirement accounts are not exempt. Spouses' assets are free game here in Arizona because we are a community property state, but they might not be, for example, in Illinois, which is not a community property state. So there's lots of misconceptions out there, and so I hope I can give you a little bit of guidance. I'm going to talk about restitution judgments just in general, the tools that the government has to collect restitution, talk about who actually collects this money, who are these scary people, how they go about doing it, and how you can help your client both on the front end to negotiate a restitution judgment that's favorable and helpful to them, and also on the back end, if, for example, your clients run into some sort of economic hardship, God forbid they get sick or their kids get sick, this will help you to help them in that situation. All right, so I promised I'd try to be a little bit entertaining. And I did try to find something humorous about the government and debt collecting, and there really is nothing funny about it. But I did find this cute little video, so I hope you can see it and hear it, and I hope you enjoy it.
Like, hey, you owe us money. I'm like, yeah. They're like, when you gonna pay us? When I get some money. They're talking about, well, how come you haven't paid us? Because I don't have any money. And my favorite was, he asked me, he goes, well, can't you borrow the money so you can pay me? I'm like, hell no. You're the only one dumb enough to loan me money. Then he went in for the kill. He was like, well, this is gonna mess up your credit. I'm like, man, have you seen my credit? There are people out there that won't take my cash.
Yeah, lots of debt collectors out there, and the federal government is definitely one of the absolute worst. So let's just dive right into it and talk about restitution. And let me pull up my slideshow here. All good? You guys can see that? Okay, so when it comes to restitution, the court has some discretion over some things and not discretion over other things. And so, as you guys know, restitution is mandatory under federal law. A court must and shall issue an order of restitution, just like the statute says. And so when it comes to the amount of restitution, the court has no discretion. It must order the full amount of the victim's loss, regardless of, how dumb, young, and broke, just to use the words of Khalid, how poor your client may be, that doesn't matter. If, for example, the victim got some insurance money, that doesn't matter either, just like in civil cases, collateral sources are not counted. But when it comes to how restitution is to be paid, that's where the court does have some discretion, and that's where you come in. And this is where you can really, really help your clients. So the statute says that the court can look at the financial condition and the resources of the defendant when determining the manner and the schedule of the payments. If your client's in prison, they may not obviously have any income, but that will be looked at when they're released. So the court will look at, what are they making? What might they make in the future? Are they educated? Do they have, dependents, kids, an elderly parent? All of those things factor into how a restitution judgment is going to be paid. So the court can order either a lump sum right up front, a partial payment, interval payments, and that's what we see most of the time, right? Or a combination of one or all of these. So I just negotiated in a healthcare fraud case that I worked on with Peter Sexton, a $2 million restitution judgment. So how we structured it is my client's going to pay $50,000 upfront, and then we figured out, what the payment would be monthly if he paid it out over 20 years, which equals to be about $8,000 a month. And in exchange for that, the government has agreed, as long as he's making his payments, they're not going to attach his house or engage in any other collection efforts. So those are the kinds of things that you can do to help your client. Now, you might think, well, my client's going to prison. Why does it even matter? Well, it does, because at some point your client is, of course, going to get released. And, you want to try to negotiate the lowest payment schedule that you possibly can. And the reason is that, it's a court order. And in order to modify that, the government has to go into court and modify it. And I'll talk in a little bit about the flu unit and what they do. And, they don't always follow the law. They sometimes try to intimidate defendants. They send them nasty letters and they try to get them to agree to things without going into court. So you want to ensure that you negotiate this upfront, that you put it in the plea agreement. And then, once the court issues the judgment, make sure that it matches, because sometimes, the courts don't pick up on that. So all you have to do is file a motion to amend the judgment to reflect the agreed upon payment schedule. Okay, so let's look at an actual restitution judgment. And I just took a little screenshot of one of the judgments I found online. So in this case, the defendant's been ordered to pay 1.15 or 1.1 million approximately. It says that this amount is due immediately. See that? However, in the next line, the court says, well, I've assessed your ability to pay, and I'm ordering you to pay equal installments of $500 a month over a period of 58 months. We can spend a lot of time talking about how these provisions are inconsistent. And if you have questions about that, please give me a call. But I want to focus on a couple of things. One, obviously, the court has looked into what he thinks or she thinks that the defendant has the ability to pay and came up with this amount. Pay very close attention to the time limit, though, because Some defendants are like, oh, it's 58 months, I'm done, but they've only paid, say $500,000. Their obligation continues on until the entire restitution amount is paid. A lot of defendants think that when their probation is done, that their obligation to make their payments is also done. And that's when they get into some trouble. All right, so let's say that you negotiate this great payment schedule for your client up front. I mean, is that it? Are they bound by that? I wish I could say yes, but unfortunately, the government can modify a payment schedule almost at any time. And that's kind of up to you to negotiate as well. You can maybe put in your plea agreement a 5-year time frame or a 10-year time frame, whatever you're thinking might work. So by motion, a court can modify, the government may modify the payment schedule. But what's so interesting about the statute is it allows any party to file a motion. So that means like a victim, an ex-wife. That's what I was thinking of, right? Some ex-wife gets angry and is like, oh, by the way, government, my husband just inherited $2 million. The statute allows the victim to file, and it interestingly does not allow the defendant to file a motion, which to me is completely unfair, but we'll talk about in a little bit, some things that you can do. All right, so I wanted to point this portion of the statute out to you because I think it's kind of hilarious, but it does require a defendant to notify the U.S. Attorney's Office if their economic circumstances materially change. I think this has probably happened never, but I wanted you to know about it, and it's something that you should counsel your clients about, that if they do come into some money, they are obligated under the statute to notify the U.S. Attorney's Office. Okay, so let's talk about who is actually collecting this money. I call them the enforcer or the blue flu, but many of you have probably heard of the Financial Litigation Unit. Each district in the United States has its own flu unit. Our unit is just happens to be down in Tucson. I don't know exactly who the supervisor is currently. I know that recently changed. But these folks are like regular bill collectors. They're like IRS collection people. They're unbending, they're persistent, relentless in some instances. And, they really don't really care too much about excuses, and they really are all not that friendly, in my opinion. So when I was in AUSA, the flu unit was kind of dormant when it came to criminal fines and restitution. They kind of focused on the civil side of the house. Well, Congress woke up, and they're like, why the heck are we not collecting more of this money? And so just a little interesting statistic for you. Between 1994, when the Mandatory Restitution Act, went into place, and 2014, the outstanding criminal debt increased from 4.4 billion, and yes, I said billion, to $101.5 billion. That is a lot of outstanding criminal debt. And so, Congress was pretty angry about that and directed the Office of Inspector General of the department to conduct a study to determine, what's happening here? Why aren't we collecting more money? And so, of course, this is true with everything. There simply were just not enough people and not enough staff and not enough AUSAs that were working in this area. So DOJ went out and hired a bunch of these folks. I think most districts that are larger like us have maybe 3 or 4 people. They used to have 1. That started in about 2016 or 17. I really could not find any statistics about whether the collection rate has gotten better. But I will tell you that these guys are on it. And they start that collection process immediately after a defendant has been sentenced. And some of you, may have experienced this or assisted your clients with some of these efforts. All right, so let's talk about financial affidavits. And I wish we were together because I'd love to see a show of hands of how many of y'all have helped defendants fill these out because they're crazy. I included a couple of samples of these types of affidavits in your materials. So you can kind of look at them at your leisure. These are something that FLU is requiring every single defendant to complete, like I said, immediately after they've been sentenced. You may have a client that got one of these, later on, maybe years after they've been released. And probably what happened there is they missed a payment. And so that triggers FLU to, start bugging you and start investigating how much money you have, et cetera, et cetera. And I laugh. I say that they let their dogs out or release their dogs on the poor defendant debtor. When you're looking at those affidavits, the first thing that you'll notice is they are pretty onerous. They're long, first of all. I think the shortest one's like 15 pages. And I mean, they ask you about everything. What property you own? Do you have a share of any businesses? Do you have stocks, bonds, et cetera? All that kind of stuff. I mean, they even ask you about like your grandmother's jewelry. I'm not kidding. I mean, they're very, very, very detailed. The worst part about it is that FLU requires that you provide supporting documentation. I mean, of course, they're not just going to take the defendant's word for it, Lord forbid, but they'll make you produce bank statements, LLC documents. I mean, you name it. Anything that you're talking about in that paperwork, you're going to have to provide supporting documentation. A lot of people ask me, my clients, do I really have to fill this out? This is crazy. And I tell them, no, you don't. But if you don't, unfortunately, the government has the ability to conduct discovery. And so if you don't answer the questions here, they're going to subpoena you for a deposition or a debtor's exam. And you're going to have to ask all of those same questions under oath. So it's kind of like you're damned if you do and you're damned if you don't, right? I mean, but it's better, I think, to put it in writing and then have be able to review that with your client in advance. Okay, so let's talk about the collection methods that the government uses. So there's two different ways that the government can collect money. The first is via a federal lien, and the second is through the Federal Debt Collection Procedures Act. So we'll talk a little bit about each of those. All right, so what is this federal lien thing? So it's set forth in 18 U.S.C. Code 3613, and I gave a copy to all you guys in your material. So take a look at it because there's a lot of stuff in that statute. I'll try to summarize it for you briefly. But basically, think of it as like an IRS lien, but worse. I mean, can you imagine anything worse than an IRS lien? Well, think of a restitution lien because it is worse, and I'll tell you why. The lien is basically attaches via by law to all of the defendant's assets, any property, and also any future interest in any property. So let's say that you may inherit something from your parents when you die. The federal government has a right to go after that property as well. Unfortunately, these liens are good for 20 long years. And a lot of people think that's from the time of sentencing and that it's a flat 20 years. If your client was sentenced to prison, that 20-year period does not begin to run until after he or she has been released. So make sure you understand the difference. And that's not being released from probation, it's being released from custody. All right, so Now we're going to talk about what is exempted property under the lien. In other words, what can't the government touch? And this is, it's kind of a complicated of an analysis, but I'm going to break it down for you. So in essence, the restitution statute looks back to the federal tax code and kind of takes those exemptions and adopts sort of the same ones, except for not all of them. And that is why these restitution liens really, really stink. And so you can look at the statute itself, and it actually cites the federal code. And notice that it has, 1, 2, 3, 4, 5, but it skips 9, 11, and 13. Well, number 9 is wages, number 11 is public benefits, and 13 is residence or personal property. So that's why these liens are a lot worse. So let me I put together kind of a list for you so you can see what's exempt and what's not. All right, so here are the things under the tax code that apply to the restitution statute. They can't take your unemployment benefits, railroad retirement. A lot of people think military benefits are exempt. It's only the military Medal of Honor Roll or Medal of Honor Roll benefits that are exempt, which I had never heard of, but those are the only type of benefits that are exempt. They can't take work comp, child support, and most disability benefits are exempt as well. So I want to spend some time talking about what is not exempt. And these are the things that you need to be telling your client so that they understand, because like I said, there's a lot of misconception about what the government can take and what they can't. So I mentioned earlier that the Arizona homestead exemption does not apply. Now, I personally do not believe that the government should be in the business of throwing people out on the street. And there's a lot of defendants that own homes before they went into prison and still own their home when they come out. If you're living fairly modestly, and let's say you want to refinance, the government claims supposedly that they will work with these defendants, but I will tell you that it is a total nightmare. I have spent the last year, I'm not kidding you, the last 12 months trying to negotiate a refinance with Flu. And, they drag their feet. And, of course, we all know interest rates have gone up tremendously just over the summer. And so by the time, the government got its act together and did what it needed to do, which was subordinate its lien, my client didn't qualify for the loan anymore. So it's just kind of a mess, but, be resistant and persistent. And typically, they'll help you, especially if the client needs to get cash out to make repairs or something like that. I mentioned earlier that retirement plans are not exempt. Now, the law is pretty complicated on this too, but just think of it this way. If a defendant can get access to his or her retirement, then so can the government. So like IRAs, SEPs, we can pull money out of those at any time. But if you have an employer retirement plan, sometimes those have rules attached to it. And, like you can't touch it till you're 45 or 55. And so if you can't touch it, then the government can't touch it either. But that doesn't mean that they can't touch it within, that 20-year period if you are able to get access to it during that time. So I hope that makes sense. Social Security, yeah, I mean, those guys actually do take people's Social Security. Now, they'll only take up to like 25%, but if you're living on Social Security, 25% is a lot. But yeah, they do it and they do it all the time. Trusts, just a rule of thumb, basic credit law, and I know most of you know this, but a lot of clients ask me, well, what if I just put everything into a trust? Well, first of all, if they see you doing that, they'll try to claw those assets back. But second of all, the only trust that really protects creditors is an irrevocable trust. And most people, they don't want to put their assets in an irrevocable trust because they can't control it. And so, and I know there's some fancy trusts that you can do overseas and whatever, but the basic trust like I have, you know, my family trust, that is not going to keep the flu away, unfortunately. They can take pretty much everything, stocks, bonds, your spouse's assets. If you live in Arizona, unless you have an airtight prenup, they can also take the defendant's children's assets like Section 529 plans, savings account, and I have actually seen them do this. All right. So the second way that the government can collect debt is through the Federal Debt Collection Procedures Act. That can be found at 28 USC 3001. And the procedures are just like any other, you know, like civil collection procedures. They can issue a writ of garnishment. They can levy your property. They can seize property. As far as a business goes, they can appoint a receiver and liquidate assets. Oh, and I forgot to mention, when filling out those affidavits, you also have to fill out one for each and every one of your businesses. So that's such a pain, but they can appoint a receiver to liquidate your business. Of course, that would be really stupid because everybody needs to have a job, and in order to make the payments for your restitution, you need to be able to make money, but I have seen that happen. And then finally, they can order installment payments. All right, so there's a lot in these statutes, but I really want to focus on one aspect, and that is the garnishment of wages, because this is a pretty important concept that you need to talk to your clients about. So basically, the government can go after up to 25% of your disposable earnings. So what does that mean? Does that mean my wages after I pay my bills? No. What it means is my wages after I pay my taxes. So, you know, basically the government can take 25% of your take-home pay. Now, you know, there's some case law out there, and I put some in your materials. I wrote an article about this, but there's some case law out there that says that 25% is meant to be a ceiling, not a floor. In other words, that's the max that the government should be taking. You know, and if your client is experiencing a hardship, you may be able to get that percentage amount lowered. Okay, and I think I'm just about out of time, but you know, you may be asking yourself, you know, is this just a hopeless situation? Is there anything that we can really do to help our clients? And the answer to that is yes. The Federal Debt Collection Act does give courts very broad discretion to modify their own orders. I've cited a couple of cases in this slide and also in your materials where the courts have actually modified payment schedules based on hardship. You know, they're few and far between. But that doesn't mean that you should not try. I've made a joke a couple times with some of my colleagues, you know, especially when we were all filing petitions for compassionate release, that, you know, we work in a district without compassion. You know, we do. We live in a very conservative district, but it does not mean that you should not try. Because, you know, I think our judges, you know, they listen. And if a client is truly experiencing hardship, you know, hopefully the court will provide some relief. So the moral of the story is for you guys and all of us to stand up. And I know you will. You guys are an incredible group of folks. I mean, I am so very honored to, you know, stand by you and work beside you. I see the wonderful things that you do for your clients and the justice that you serve. And the bottom line is, you know, if we don't stand up for our clients, then nobody will. And for years and years, nobody has really stood up to the flu. You know, they've kind of done whatever they wanted. And I think if more of us file these motions and we intervene on behalf of our clients, maybe they will stand down and stop, basically trying to get our clients to pay an unreasonable amount of money. I cited here, some of you CJA folks, you can get funding for this kind of thing. All you have to do is ask. My last bit of advice would be, at the end of your case, go over some of these things with your clients, talk to them about restitution, let them know that if they get that affidavit, give you a call and you'll help them fill it out, and tell them, hey, if you run into hard times, give me a call and I'll help you down the road. I'll help you get it sorted out. So I just want to end by sharing a little clip from my favorite movie. And it's really just about standing up for what you believe in, standing up for your friends, standing up for your clients, and, also standing up to bullies. So I hope you guys enjoy this little, let's see if I can figure it out. Hold on just a second.
Because Wood drastically underestimates the impact of social.
Wood drastically underestimates the impact of social distinctions predicated upon wealth, especially inherited wealth. You got that from Vickers, working in 6 County, page 98, right? Yeah, I read that too. So you're going to plagiarize the whole thing for us? Do you have any thoughts of your own on this matter? But is that your thing? You come into a bar, you read some obscure passage, and then pretend you pawn it off as your own idea just to impress some girls? Embarrass my friend. See, the sad thing about a guy like you is in 50 years, you're going to start doing some thinking on your own. And you're going to come up with the fact that there are 2 certainties in life. 1, don't do that. And 2, you dropped 150 grand on a fucking education you could have got for $1.50 in late charges at the public library.
Yeah, but I will have a degree. You'll be serving my kids fries at a drive-thru on our way to a skiing trip.
Yeah, maybe. Yeah, but at least I won't be unoriginal.
Wood.
I love that, Liddy. I love that movie. Well, again, I have my email and phone number and everything in the presentation. Please feel free to give me a call. Oh, I thought I did. Maybe I don't. But please feel free to call me or email me anytime. I'm not the best about returning calls because I don't always empty my voicemail out. So just text me and my email will be in your materials. And thank you so much for, letting me be here and talk to you about something that I'm really passionate about. And go out there and keep fighting for your clients, y'all. Have a good day.